Welcome to show 5 of the Cyber Incision live stream named Cutting into Cybersecurity, or CIC. Now, in this episode is a continuation of the CISSP certification prep, where Brandon and I will be digging into each domain, discussing the topics related, answering questions, and providing real-world examples for those looking to expand their knowledge or get certified with us. So for those of you who don't know us personally, I'm Joel Bork. I'm your host here at the Cyber Incision livestream, and I'm joined by our senior account executive at Usato, Brandon Krieger. Thanks for co-hosting with me, Brandon.
Oh, thanks, Joel. This is amazing. We're at episode number 5.
And so those of you who have been with us for a few weeks, we've changed our look, changed the name of the brand. We had over 100 views of this over the last week since we went live with show 4. So really exciting stuff. Now, Brandon, before we jump into show 5 of this show, do you mind giving us a 2-minute recap for those of us who weren't able to join last week?
For sure. We can do a little bit of a recap. Cool. Also, I want to do some housekeeping as well after what we'll do the recap first. So last episode, we had Garev, an attorney who is a CISSP. He was helping us out through the episode, talk about a lot of law. So we covered criminal law, civil law, and administrative law, along with the difference between due diligence, due care, and how it relates to organizational liabilities. Then we jumped into the legal aspects of investigation and real, direct, circumstantial, secondary, cooperative evidence, along with hearsay. Mm-hmm. Then we touched on chain of custody, reasonable searches, entrapment, enticement. Then we wrapped up the show we discussed the different types of computer crime. So we covered a lot of information. Now, just so you guys know, check out the previous episode and every previous episode that we've actually recorded, just so you can get a lot of the information covered, of what we've covered so far up to this point. Next, a little housekeeping. We're on the chat. We're live on the chat. So if you guys have any questions, make sure you comment. We're watching that as well. Raise your hand, put something in there, ask any questions for the episode that we're doing right now. Second is share this with a friend. Something that we haven't really kind of been asking for, but if you know someone that's going for their CISSP, someone that wants to go to that next level and wants to study with us, share this with them and have them come out, because we're answering a lot of questions. We're giving real life scenarios. Joel and I are looking for experts in the field to bring on the podcast and this study session live to be able to go through everything to cover real world situations for you. So really, I find it beneficial. What about yourself, Joel?
Yeah, no, especially having Gaurav, having a lawyer on, being able to discuss those topics, talk about circumstantial versus corroborative evidence and how it applies in a court of law. Like it was something I've never heard before, right? And it made it so much easier to learn it than actually referring back to the book itself, right? Reading a few paragraphs, like it just made it so much more real world. Was it the same for you?
Oh, it was. And he was talking about situations and how it was prevalent and what, how he would use it as a lawyer in a real life situation as he's doing it. So it gave you real contextual versus kind of like you said, theory, where you're reading it and it's like, okay, but he was talking about scenarios and situations where business cases that, it would come up. So
that's it.
A lot more value.
Yep. Now, this week we're going into understanding legal and regulatory issues that pertain to InfoSec in a global context. So I see we got a few reactions already. Abina Asantewa from IBM, welcome. We also have Benito Quadade from HP1. And then we also have Vural, who was waiting, a software engineer. I don't see your organization listed in your title, but welcome to the show. Thank you guys for your reactions. Welcome, and let's jump right in.
Let's go.
Cool. So up first is intellectual property. So as opposed to physical or tangible property, intellectual property, as you guys definitely know, is intangible and is a result of a creative act, right? So a lot of software development, all of that IP is known as intellectual property and will fall under those laws. Also, welcome, Sean. I see you just joined us, so welcome to show 5. We're glad to have you back. You missed the intro, but I'm sure you'll survive. Now, when we're talking about intangible property and intellectual property, a lot of this can be trivial to reproduce, right? So once it's public and known, I'm talking like copy paste easy to reproduce. So the following intellectual properties, these concepts effectively create an exclusive monopoly on their use. So let's jump in. Brandon, you're up first with trademarks.
Let's talk about trademarks. So trademarks are associated with marketing. right? And all of us are doing marketing right now. I mean, we're looking at, even our, new brand, right? The purpose is allowed to the creation of a brand that distinguishes the source of the product or service. Example, a distinguishing name, logo, symbol, or image. These represent the most commonly trademarked items in the United States. Two different symbols are used with distinct marks that are individual or organizational is intended to protect. The superscript TM trademark symbol can be used freely to indicate the unregistered mark and shown in figures, and they're showing here.
So pause on that.
Yeah.
So this is for the unregistered trademark. You'll see the TM in the corner, right? So if it's unregistered, the trademark organization wants you to put the TM up there. Now, most everybody sees the circle with the R, right? That's for the registered mark that's been formally registered and approved by the trademark and U.S. Patent and Trademark Office.
Right. And that's where you see, like, when you're looking around and you're going through, your Google search, your Google images, right? And you're seeing that this is the things that are being protected, right? And then we're looking at trademarking and registered, right? The circle, like you said, the symbols is the mark that's formally registered as a trademark used by the U.S. Patent and Trademark Office. So again, this is talking about United States specific. And from my understanding, a lot of the questions in the CISSP around U.S. regulations and trademarks and things along that line. Is that right, Joel?
Yeah, it is right. Now, I think Canada pretty much follows U.S. regulation on trademarks, right?
Yeah.
Okay.
I mean, I owned a marketing company, same thing, right? When I was in my marketing company, when I look at IPOs, trademarks, registering any of logos, branding, same thing, right?
Gotcha. Now, there's one other type of mark you're going to need to know, and it's called a service mark. Now, a service mark, the symbol is SM above the name or logo, and that's used for a brand to brand a service offering rather than a product like Nike or a company like Apple. Now, a couple real world examples. Now, at this point in time, hopefully, I don't know if hopefully is the right word, but most people have seen the show Tiger King by now. Have you seen it, Brandon?
Yeah, I saw a little bit of it, and then because of the conspiracy and everything was going on, I was like, okay, I gotta study. Like, I don't have time to watch this.
I mean, it was something we binged it probably in a couple weeks, but there was one lawsuit in the show that was a trademark lawsuit. So for those of you on the show, if you remember this, he basically stole Carol Baskin's logo and started using it. And she basically pressed charges and that he was ripping off her trademark, and she won the lawsuit. Or while the lawsuit was in play, they basically locked up some of his funds, which put him in serious financial duress. And that led to some of the actions that landed him in prison. So that was a trademark lawsuit.
Wow.
Yeah, crazy stuff. Now, a couple things. Sounds like you've applied for a trademark. I also have. But if you have ever considered applying for a trademark, it's a couple $100. And you have to make sure you get the right codes selected for the type of trademark it is, because if you get them wrong, they don't let you switch them out, and you have to start all over again and pay the fee all over. So just a little life hack there. Now, you can also do that process without hiring one of the bajillion trademark lawyers that will indefinitely reach out to you as soon as you file for that, but it does take some time and effort if you're not going to pay a lawyer. Cool.
Yeah, I mean, like you said, there's a lot of information online too that you can find this out. So
totally,
right, and how to do it. Back in the day when you did it, when there was no Google or internet, yeah, it was a lot of paperwork, a lot of figure out. And yeah, you had to sit down with a lawyer. But now, because of Google, I'm sure there's a YouTube video somewhere that you can figure out how to do it. Exactly.
Right. Cool.
So next, we're talking about patent.
Mm-hmm.
So patents provide a monopoly to patent holders on the right to use, make or sell an invention for the period of time in exchange for patent holders making the invention public. Yep. Now, you hear this a lot on Dragon's Den, right? You hear about patents and they're getting their patent pending and all that. So it's very important, like when you're looking at how this protects, what they're building and what they're working on. Because during the life of the patent holder can, through the use of civil litigation, exclude others from leveraging the patent invention. So if they're inventing some product or service or whatever that may be, some innovation, they can actually now protect it that someone else is trying to make something similar, right? And they can actually protect that patent.
Yeah. Now, it's really interesting when we talk about patents because when you think about why it was created, it's brilliant, right? Hey, we want to move the human race forward. And if somebody invents something, we don't want to keep it a secret. We want it public knowledge so we can iterate and evolve that. So that's where a patent came into play so that that person can protect it, but they make that patent public. Now, it's gotten wrapped up in a lot of bureaucracy, But still, for a product you're going to patent, it has to be novel, it has to be unique. But you guys have all heard the saying, there's nothing new under the sun, right? So most inventions are an evolution of an invention that's already occurred. So that's why the patent process exists. Now, it looks like generally in both Europe and the United States, probably Canada as well, Brandon, but basically the term is 20 years from the date you file until it expires.
Yeah, and I mean, that's good to know, right?
Mm-hmm.
Especially when you're creating a product.
Yeah, a physical, tangible invention, right? So a quick example, Velcro. So for those of you who don't know, Velcro was invented in Switzerland in 1941 by George de Mestral. Now, many commercial applications, many people wanted his fabric hook and loop fastener. Well, he applied for the patent in numerous countries throughout the 50s, and then he trademarked the name Velcro. So while the invention is out of patent, the trademark, Velcro itself, is still under trademark, and those don't expire. So trademarks don't actually expire. So Velcro, you would still have to pay him for the use of that. But you can use his invention all you want, and you can reproduce it and manufacture it on your own if you desire.
Now, here's a little fun fact. I remember reading Think and Grow Rich,
Mm-hmm.
and they were talking about Thomas Edison. He had 1,000, they're estimating, around 1,093 patents.
Wow. Now, for those of you in an organization, maybe a startup, a lot of startups are acquired, and the companies acquire them take into account how many patents you have. So companies will buy you just for your patents alone if you have some quality patents. So just 2 cents there.
So now, you guys that are watching right now, any questions about patents, any comments, your experience working with patents, working with trademarks, comment in the comment field on LinkedIn. We'd love to kind of hear your feedback.
Yeah, absolutely. What experience you have. We'd love to read it and discuss it here. This isn't just about us regurgitating the info to you guys. While there is a ton of info for the CISSP certification, we want this to be something where we can communicate, talk about it, and make it stick, right, for everybody here present. Cool.
For sure.
Next up is copyright. You ready?
So copyright represents a type of intellectual property that protects the form of expression in artistic, musical, or literary work, and typically denoted by the circle C symbol as shown in figure, and then it shows kind of the C 2010 synergist. The purpose of the copyright is to preclude unauthorized duplication, distribution, or modification of a creative work. Now, is there anyone that that's been compromised that way?
From
Anyone
copyright?
you can think of? From copyright.
No. Who do you have in mind?
So one thing in social media, you see this a lot right now, especially because of Google Images.
Okay.
I know from, back in the day, I saw, people grabbing images, right, from Google Images and using them that were copyrighted, right?
Yeah.
They weren't license free. So there's, when you're getting images, there's ones that have free licenses that you could use and use it for marketing, and then ones that don't. So you get a lot of times where people don't use them, and now they have embedding and coding in that, and they start to watch where these images are going. You can actually be contacted by a lawyer for a copyright infringement.
Wow. Yeah. And so if you're looking for free photos to use for a presentation or a paper or a post even, right? Look up royalty-free images. And those are the ones that basically don't have a copyright on them. And there are a lot of artists out there who just take photos just to take photos, and they're not trying to sell them, and they'll throw them up online royalty free. But yeah, be careful just Google searching and grabbing the first photos you see.
And then read them also. That was one of the catch that I found, is read what you can use them for, because some of them you have to have reference material that you have to reference the actual creator, whatever that may be. So make sure you read all the terms of service, that how you can use it. Mm-hmm. Some, you can't use it for paid advertising. So make sure you understand that.
Yeah. Now, copyrights are enforceable for 70 years after the death of the author. So if you copyright something, Brandon, I have to wait for you to die, and then it's 70 years after that. So let's take into a real example, because the crazy part is the U.S. keeps extending the copyright durations, so you can basically apply for extensions after that date, and most of it's because of Walt Disney. So if you know who Mickey Mouse is, which I hope you do, he's the reason these copyright laws keep getting extended. So this curve of time that copyrights are allowed to be in existence is appropriately labeled the Mickey Mouse curve. So if you guys are aware, if you guys ever saw the original Mickey Mouse, it was like a mouse that was whistling on a boat, steering the boat. His name was Steamboat Willie. So that version of Mickey Mouse is just now coming out of copyright. But the actual Mickey Mouse everybody knows and loves, yeah, it's still under copyright because they keep extending that. And I want to say it's pushing 110 or 20 years after Walt Disney's death.
Wow.
Yeah. Yep. So pretty wild.
So yeah, we're talking about like copyright limitations. I'm just kind of looking at the graph here that we had, and you're looking at, Sony Bono Act, the 1996 Act, 1976 Act. So it kind of shows how things have progressed over the years, the copyright. So, I mean, do you remember music? I think, music is 50 years? Is that?
So music is, when we're going to get into intellectual property attacks, but I want to say that's a copyright as well. So that is 70 years after the death of the author.
Okay, yeah, because I was trying to think of that.
It's a musical, literary work or artistic work.
Wow.
Yeah, so that's music.
So let's talk about copyright limitations. Two important limitations of the exclusivity of the copyright holder's monopoly exist. The doctrines of the first sale and fair use. The first sale doctrine allows a limitation. Purchaser of copyright material is to sell it to another person. If the purchasers of the CD later decides the CD would be copy, distribution later decides that they no longer care to own the rights. The first sale doctrine gives the legal right to sell the copyright material even though they are not copyright holders.
Yeah, so basically if somebody who bought it under copyright wants to resell it, they can. And then if they want to resell it, they can, even though they weren't the original copyright holders. So looks like Tim Lesnick, he said, those of us here in Orlando love the Mickey Mouse factoid. Yeah, of course, because in foreign countries, they don't abide by the same copyright and patents laws. So they, like, if you go to China, they'll make all the Mickey Mouses in the world and sell them for $1 or $2. But yeah, down in Orlando, man, it's still a $25 Mickey Mouse stuffed animal like this big for your kids. Get those tourism dollars at work. So now, real quick, we're talking about copyright acts. So there's a few acts you guys have to know, right? So the fair use doctrine, this is when it allows somebody to duplicate copyrighted material without requiring the payment. So remember when you guys had a CD? I know this is this aging us? I hope everybody hears. Yeah.
So hold on. Let's do a poll. Okay. How many people here that are listening remember CDs? Right. Let's start with that.
They have to. Come on. They're not that old, right? Everybody here had a Walkman, right? Walkman. Give me like a thumbs up or a little clappy mark on here real quick if you had a Walkman. I'm not talking the tape player Walkman. I didn't even have one of those. I'm talking a CD Walkman. Did you have a tape player Walkman, Brandon?
I had a tape deck. I had the old cassette. The yellow one. I had the Sportsman.
Did you? I had
I had the Sportsman. One with the clasp over, the yellow. Oh, I was rocking it.
I'm just glad headphone technology has come a long way. Do you remember the old fuzzy headphones we had? All right, we got a couple thumbs up. There we go. That's what I'm talking about. You had my Walkman. All right, so when you had that CD and you threw it in your computer, it may have taken an hour to download that and copy the songs, but you could actually copy that. So when iPods came out, you could then put it on your iPod. So that's one of the 4 factors of the Copyright Act of 1976, right? So it determined whether a use or whether something under copyright could be covered by the fair use doctrine are the purpose and style of the excerpt, the nature of the copyrighted work, the amount of content duplicated compared to the overall length of the work, and whether the duplication might reduce the value or desirability. So just because you duplicate a song and put it on one device or another, it doesn't reduce the value of a song, right? But depending on the type of work, it may. So those are a number of those facts there. So hold on. Looks like Tim's saying he had the Sportsman and Walkman all day long.
There you go. See? Man after my own heart. Now let's talk about Napster. Right? So we're talking about that. So Napster, this is something that you disrupted the whole industry, right? Mm-hmm. When you looked at all that CDs and all that was all now brought onto online.
Yep.
MP3s, and now you're able to download, disrupted the whole music industry.
It's true. Now I got to put I got to put you on pause because that's literally coming up here in 1.5 more sections, right? When we get into intellectual property attacks, because we're going to get into all that stuff you guys used to do that you weren't supposed to be back when you were teens, LimeWire, et cetera. So we'll get there, but we're almost there. So let's real quick jump into licenses. So most software licenses, right? But most licenses people see are the EULAs. Right? So you're like, okay, you want to sign up for this website, scroll through all of this, and then click approve after you don't read any of it.
So let's ask. I want to do a poll. How many people actually take the time and read the acceptable use license of anything they install? Android, iPhone, application. Comment below. Do you read it? Yes or no? I want to see how many people read it, because I know for me, unless I have some hours to spend, I'm not reading through it. Right? Unless there's something I'm really concerned, because most of them are telling you already, from my understanding, as a security professional, they're going to try to get access to something. They're going to try to get access to some sort of data. They're going to market it in some way, your data, and somehow, right? A lot of them say that in the actual that they have access to it. Yeah. And so I like to hear what these guys say. Tim, never. No, and me either, right? Tim, it's probably been... Oh, man, 8 years since I even read the first few sentences of one of those. Is that sad? Right. Is that sad as a security professional? That's just the world we live in. Everybody's got a EULA that's 50 pages long. Who's got time for that? Lawyers. Lawyers.
That's it. Yeah, you're right. All right, so that's licenses, right? So software licenses, they have things that will explicitly make the user agree to it'll tell you explicitly how to use that software and say you can't modify it, etc. So looks like Earl said he's like, I copy it just to have it. Do you really, Earl? You actually copy it and save it off?
That's awesome.
He must have a hard drive filled with them at this point. I'm curious how you do it.
So now my question is, how does he label them? How does he organize that? Because there's just so many, right? Yeah. I know for me, and I did this on my hard drive when I lost my last Mac, and I was going through all the applications I had previously in the new ones. I had probably a list of maybe 150, 200 applications, right? And now storing all the, the user license, right? The EULAs to there, and then going over that the years. I don't know, Joel, how many apps do you think over the last 2-3 years you've gone through?
Apps?
Applications.
On just my iPhone, I probably have 120.
Right.
And I got that phone last year, right? So I had to go through and
So imagine that, Earl. You're a man. You're amazing. If you're going to keep those and organize that, I'd like to hear how you're actually keeping them and storing them, because I know for me, I'd probably have them in some folder, and then I'd lose them right over time and distance because of all the data that we store.
That's true. All right, but we got to hop into these trade secrets, right? Because we got to get these intellectual property attacks. So, give me an example of a trade secret.
So trade secrets are business proprietary information that is important to an organization's ability to compete. The easiest to understand trade secrets are the special sauce, a variety. It's bringing Kentucky Fried Chicken could suffer catastrophic losses if another fried chicken shop were able to crack the Colonel Sandals' secret recipe, secret blends of 11 herbs and spices for the result of the finger-licking goodness. So how many companies do we know that have that? And then we hear about that constantly, about espionage. I was talking about that actually today with a client about corporate espionage, right? And how prevalent it is. One thing they were talking about, and not to release any information, but it's drones.
Oh,
right?
Interesting.
Drones, we were talking about that, just in drones of collecting, information and transmitting data, right? They can be actually, release proprietary confidential information depending on if they're flying over,
but not trade secrets. So we're
maybe
talking, that's data leakage, right? So that's going to be bucketed under intellectual property tax, because I was just having a conversation with a buddy of mine who does hardware hacking, and that's one of those things. So if you guys have seen that AWS just got approved to deliver your package with drone, 30-minute delivery, hallelujah. But in reality, hacking those devices, imagine if somebody could catch one of those midair and redirect them to their house. I've seen it.
Okay.
I've seen somebody hack a drone in the air. So it's possible. It's just a matter of time until they do it to AWS ones. But we're not there yet. So trade secrets, Kentucky Fried Chicken. Give me a couple more examples. I mean, we're on the chicken loop. So Chick-fil-A has their own secret recipe for making it perfectly crispy and juicy. Oh, I'm a Chick-fil-A fan. Chick-fil-A. Chipotle's probably got their own secret blend, right? So we're in the food space. But you got to think trade secrets are like, now Elon Musk open sourced his battery technology, but other people who have like special trade secrets, maybe that's not a good example.
Manufacturing companies.
Oh, here we go. Tim's got a great one. Coca-Cola's formula. Boom. It's in a vault on the moon. I believe it, right? They shipped it to Mars already, so whoever can get there first gets their secret recipe.
I understand how Coke is made. But yeah, but even manufacturing companies, like, big companies like Kraft and the ones that, they have trade secrets on their assembly lines.
Yep.
Right? And you look at even, I'm going to assume this, and correct me if I'm wrong, guys, Apple, and how they design their stores. A lot of that is trade secrets on the special screws they use and everything. Everything is custom designed.
Oh, wow. Now, they make their employees sign NDAs, right? So everybody on this call, hopefully you've had an NDA, but you have to use a non-compete or a non-disclosure agreement when you're dealing with trade secrets. So that's what they use for employees or other people who are privy, right? So if you have a partner coming on, they sign an NDA, and then they're basically agreeing not to reveal that intellectual property. Now, those are difficult to uphold in court. NDAs and non-competes are very difficult to uphold in court, but it's still required to have. You got to do it.
So non-competes. Let's quickly talk about that, and I mean something maybe Tim can chime into with Garev. Is that with non-competes? From what I was told, companies sometimes get you to sign this, but they can't hinder you from making a living. So it's actually one of those things where there's a little bit of a catch there. When I was talking to a lawyer about this, and they said you can sign a non-compete if you work for a company, but they can't hinder you from making a living. So if you're in the cybersecurity space, like all of us are, and you work in say hacking, right, or you're a pen tester, well, if you go out and open up your own business in pen testing, they can't stop you. They can't stop you from competing in that industry if you're already working for a pen, because if that's your living. Yeah,
I know. So. Right, you have, like, for instance, we had one of our best product managers, fantastic guy, left our organization for a competitor.
Right.
Can't stop him, but he knows our platform like the back of his hand, right? So we just have to evolve and hire better talent and go and deliver on the next phase of trade secrets.
Exactly. And I would say this, and just so everyone's watching this, anyone that's with the non-compete, I mean, you want to be ethical too, right? True. You don't want to, take all information from the company and then run and go, right? So there's actually a moral clause there too for us individuals, right? Because we want to help and we want to be, collaborative with your partners and people you leave with. You don't want to burn any bridges.
That's it. All right, now we're on to intellectual property attacks. So the most well-known intellectual property attacks are software piracy, right? And copyright infringement. That's the one everybody knows, right? Whether it's music, movies. Think LimeWire, Pirate Bay. Those are two really good examples. So real quick, if you're listening and you're on your computer or your phone, hit once again, just smash the heart button if you miss LimeWire. Can you smash that for me, Brandon?
There you go.
So Pirate Bay, if you ever used LimeWire, just hit the heart button. Tell me you're using it or have used it. That was BitTorrenting, right? So I looked it up right before this call when I was talking to Brandon, and Pirate Bay is still up, and it is named the galaxy's most resilient BitTorrent site because they're not doing the piracy, but they're the platform that it occurs on. And that's what brought them into so much heat back in the day, because the government had shut them down multiple times and found their different sites, arrested the guys setting it up, and it's still around.
So my question is, okay, let's put this out there. Just how many people are, remember it and used it frequently? I mean, I know for myself, back in the day, 7 years plus, right? I was an avid user. I almost left it on my system. I had a system alone just for that. And I remember I'd come home and watch seasons of shows, right? It wasn't the point where it was just one or two episodes. I would watch seasons of shows, 24, you name it, right? Whatever the shows were going out there, I'd have seasons of them.
Yeah. And I'm telling you, if you go for your clearance now, Earl, I'm not sure if you remember, you have a poly, but if you go for full scope, they're asking you if you have ever broken copyright and data infringement laws. And you have to disclose it. So when I went for mine, I'm like, yeah, I downloaded a load of stuff off LimeWire, and they ask you about it. They literally go through and they're like, okay, how much was it? Do you still do it? When was the last time you've used that data? Did you share it with other people? Now, the fact that I downloaded it, probably not the best, but the fact that I didn't redistribute it was key, I believe, in my opinion. But Earl, I'd love to hear your feedback on it.
Yeah, and I believe that too. I think it's, like you said, that gray area of usage, right, versus distribution, right?
Mm-hmm. Yeah, that's key. Now, Tim had a few comments for us. Well, Earl said I cannot confirm nor deny that, but that's fine. But they do. You got to be careful with what you're doing online. So Tim also said most companies will just fire that employee versus dealing with paying with the bill, right, or putting the liability on the employee themselves, and he's absolutely right.
Right.
Yep. Absolutely. Okay, so real quick, other common intellectual property attacks are against trade secrets, right? So trade secrets can be targeted in corporate espionage because of high-value trade secrets. Give me an example, Brandon. Besides Kentucky Fried Chicken, finger licking good recipe.
That's malicious.
Yeah.
Well, I mean, we hear this trade secrets when you look at the military, right? Constantly. I know the one thing that we were talking about before was the U.S., the F-35 versus China J-20. This is the great example of government espionage, not similar to what happens to corporate espionage schemes, right? Mm-hmm. So did you want to talk a little bit about that one?
Yeah, so this was an interesting one, right? We were talking about corporate espionage, but government espionage happens too. And there have been tons of articles lately about the Chinese Air Force becoming a serious security threat because what happened was they got into our systems and stole F-35 plans. So if you go online right now and type in Chinese fighter jet versus U.S. fighter jet, you're going to see a side-by-side picture of the U.S. F-35 and the China's J-20. They're basically identical. And that's because we knew we were being breached at the time. We know we had security incidents around the F-35 business. It's still top secret classified data, so they haven't publicly released that information, but we know it occurred. And they literally ripped off his cloaking, so stealth fighter pilot planes. Right. So yeah, I recommend guys look it up, but that is... that's a trademark attack. That's an intellectual attack against, not a trademark, trade secret. All right. Now, trademarks can fall under a couple types of attacks, including counterfeiting, delusion, cyber squatting, and then a subcategory of that is typo squatting. So you want to take counterfeiting?
So counterfeiting involves, and now, what was it? Leonardo DiCaprio? You remember that movie? Catch Me If You Can?
That was a great movie.
Right? This is a prime example of counterfeiting involves attempting to pass off product as if it were the original brand product. Counterfeiters try to capitalize on the value associated with the brand. I think a guy selling Gucci on the street corner, but that one where he was writing checks, right?
Yeah.
Right? Leonardo DiCaprio was writing checks from the companies, whatever companies he was pretending to work for, and he was forging those checks and cashing them in, right?
Yep, absolutely. Now we have a participant on the call, and I'm apologizing. I'm gonna go with this, but Gopang said Apple AirPods versus OnePlus Buds, right? So sometimes you don't have to hack into the organization to steal kind of trade secrets, but you could just reverse engineer it, right? So this happened a lot in the Middle East, right? When one of our drones crashed, they'd go collect all the pieces and try to piece it back together and figure out how we did it, how we made our Reaper drones.
My question to that is, because a lot of these products are made overseas, are they just finding out the designs in the factories?
Well, and that's also there's a lot about trade, and the trade war is that China doesn't stick by our trade. They basically block our business and allow their organizations to thrive. So if our trade secrets get into Chinese employers' hands, they encourage the production of that product because it'll increase their GDP.
Right.
Yeah. So it's an interesting balance of power there.
And discussion, the discussion point's kind of offline, but I think when you look at technology, and a lot of the technology is made overseas, like in China and all that, in the factories, they have the plans, they have the designs, they have all the elements. So the question is, even if you look at that like online, you can see all the different brands and different versions of these things being made.
Yeah, absolutely. And so the next one is trademark dilution, right? So dilution, and this typically represents an unintentional attack. So not quite what you were talking about. This is a little off, but it's basically a brand name used to refer for a larger general class of products, and then the brand name is diluted, right? So the one of the biggest examples of this is Kleenex, right? Everybody says Kleenex or tissue, right? There's really no other word for it, but people say, hey, pass me the box of Kleenex, right? And Kleenex itself is a brand, but you use that word for the entire industry. And that's diluted the value of a brand, that now if you market Kleenex and somebody goes to the store, the brand doesn't mean anything. You're not going to go find a box of Kleenex instead of the cheaper brand, right? It's just trademark dilution.
Right.
Yep. The next one is cyber squatting. Have you ever seen this happen? You're going to see this a lot.
Have I ever seen cyber squatting? The primary motivation of cyber squatting is money. The typical intent is capitalizing on traffic.
Let me jump into it for you.
So yeah, I've actually seen this. Okay. I've actually seen this in my marketing company. I was kind of reading this over a little bit last night, but yeah, I've seen this.
Yeah, so there's a couple ways people do it. Now, cyber squatting, some people are like, well, isn't that just a phishing attack? Now, what cyber squatting is somebody will basically use a domain name that's associated with somebody else's trademark. So take a brand. Give me any brand. Give it to me.
Good. Nike.
What was that?
Nike.
Nike?
Nike.
Nike. Like what? Nike. Yeah. Okay, so Nike. You could go Nike shoes, NikeDiscountedShoes.com, right? And if you can increase that popularity on, let's say, Google, on the Google results, you're basically cyber squatting on a different brand, right? Because if you can raise that enough and they're saying, okay, that looks like a legitimate domain, I'll go check it out. And this happens all the darn time, cyber squatting. Now, the primary motivation for cyber squatters is money, right? Either for ad traffic, because the more people who click that link, they'll get ad traffic. But also there are people who use it for phishing purposes. So if you actually go, fall for it, they get ad revenue, and then they may have additional malicious purposes on that webpage. Now, typo squatting is a subcategory of this, Brandon, but this refers to basically them using misspellings and mistyping of legitimate domain trademarks, right? So one of the big ones back in the day was if it was a capital I, they'd use a 1, or if it was a 1, they'd use an I, right? Or an O, they'd use a 0, right? So really kind of typo squatting things to, once again, trick users to click the link.
No, the one I saw with, again, I'll go back to cyber squatting. Sometimes they buy the domains and they buy the different domain. Like, so if you had .com, .ca, .org, .net, they would buy, if you had .com, they would buy .ca on you.
Yep.
Right?
Can
So
I
what
tell you
happens?
the funny part?
Go ahead.
No. All right, I'll go ahead. Sorry, I interrupted. I was working for a company, contracting out for a company doing hunt as a service, and they had a program for the last decade where they would buy up every single one that somebody else bought.
Oh my God, yeah.
And they ended up with 6,000. They're like, we just couldn't, because every year we're paying millions of dollars to just hold these domains and not use them.
Hopefully that one will sell, right?
No, just so somebody else didn't typo squat on them.
Oh, really?
Is that insane, or is that insane?
Yes, yeah. I get the people were harvesting them before, right? Because they were hoping if someone would come buy a big company and then they want to buy it, right?
Right.
If you grabbed Amazon.com first, right? Imagine how much that would have been worth, right?
Or if you have a 4-letter one, those ones are worth a fortune right now. But you're right.
Right.
Absolutely.
So things like that, and that's where I saw it from the marketing company, where you tell them, you advise them that buy everything that's associated with .com, .net, .org, whatever that may be, .ca, and make sure you own that.
Yeah, absolutely. Now, Tim had a quick comment for you. Escalator, Xerox, absolutely, right? Go Xerox this. Great examples, Tim.
Well, it's interesting, and just kind of quickly, it becomes a verb.
That's it.
Facebook, Facebook Me, when Facebook first came out, it became a verb, right? It became an action, not a social site and the place where you go, hey, when you're on Facebook Me later, right? It was actually a verb, right? And this is kind of what they're saying, right?
You really say Facebook Me later? I
didn't. I was watching the movie.
Okay.
But you say tweet me, that when all these come out, right?
That's true.
You know what? I'd be honestly, probably when it first came out, when Facebook came out in 2004, I probably did say it. I probably did say tweet me later, or Facebook me later.
Friend me, right?
Maybe, yeah, maybe
something like that. But yeah, probably. And so I don't know, because some of those are really you almost want that to happen to your brand, but I could see there would be some unforeseen consequences of that occurring.
Google it.
Just Google it.
Yeah, prime example, right?
But let's be honest. Is anybody using Yahoo search engine right now?
Nigo Peng just said the same thing, right? I just said Google it.
Google it. Well done. Oh, that's too funny. But you're right. But that, I don't know about you guys, but I've been a big proponent of DuckDuckGo lately just because it doesn't track your stuff.
Nice. Yeah.
Yep. So Go Google it and use DuckDuckGo when you do it.
There you go. That's awesome.
All right, man. Privacy. Ready?
Yeah, let's go.
All right, let's do it. So privacy, guys, this is the home stretch for us on this episode. We're going to jump into privacy and a few of the laws and privacy stances in which countries are taking. And you have to know this if you guys are going for the CISSP certification. So let's go ahead and jump in. Privacy is the protection and confidentiality of personal information. So if you've heard of PII, social security numbers, financial information, annual salary, bank account info, all of that's PII and privacy. And countries and governments are trying to regulate how corporations can share this data, whether just to themselves, but in different parts of the world or with other organizations. I mean, you guys heard it. What was the big breach with Facebook where they were using a third party? I'm blanking now.
Yeah, it was, I know which one you're talking
Data
about.
Analytica. Was it Data Analytica? Something like that.
It was, and it was a survey, right?
Yep. Yeah, it was, but they were sharing all their users' data, and it was like a massive leak, right? So these are some of the privacy stances that are trying to prevent that.
So now here's a little question for everyone. What information do you need to create your identity? Out of the PII, do you know, Joel? If you do, let everyone answer first.
Repeat the question. Repeat it.
So what information from PII do you need to recreate your identity? What 3 or 4 pieces of identity do you need that you can go to, and for us it would be Service Ontario, but you can go to your local government and say, look, I want to create my identity. What 3 pieces or 4 pieces of identity do you need? Now, if you know, just hold on. I'll get you guys to answer that, because this is why it's so important to protect PII. Do you know, Joel?
I mean, it can't be much. First, last name, date of birth, and social?
What do you guys think?
Is that it?
Oh, it's simpler for us in Canada.
Really?
Yeah.
I mean, because I was thinking like, okay, really comprehensively, you have to have your driver's license number.
Right.
But yeah, that's about it. It's really 4 or 5 pieces of data. And all of that's probably online somewhere at this point in time for all of us.
Well, this is the thing. Then this is the thing that we're like, that's why I'm asking these guys out here to see what it is, because like you said, PII information, a lot of times we're giving that information away to companies, right? I mean, how many people do dark web searches? Like, I don't know if you do. Do you go through like the dark web searches?
Yeah.
So we use ID Agent, which is one of the companies that we use, right? And then what happens through ID Agent, we're doing dark web searches, and you can see how much people's information's out there. So Sean says name, address, and phone number.
Is that it? That's all you need?
So for us, it is a combination of the information. So, and that was, now Sean, just a question for you. Is that the U.S.?
Yeah, I'm going to guess it's U.S.
Yeah, because he's out in Chicago.
Yeah, if you could do your phone, you got multi-factor. You can do your address. They can send you a bill, right? Because all those companies require you to take a bill in to prove your address and identity that you live there and can access the mailbox. But how hard is it really to access some people's mailboxes?
Most of them, I mean,
mine's locked, but most aren't, right?
Well, I mean, it's okay. So
is
let's
your
talk
mailbox
about,
locked?
Let's talk about physical. Well, mine's actually in the door, and it goes in. So you actually have to break down the door to get into it. So here's the thing now let's talk about physical security, right? This is kind of where my expertise were for like 10 years. If someone wants it and it's on your wall, they're going to rip it off the wall. They're just going to take it. They're going to take the whole thing, right?
You're
if
right.
it's lockbox, whatever that may be, they're just going to tear it off the wall. Now, don't get me wrong. If you have it securely bolted in, like my wife always blames me about this, is that you could hang off of some of the things that like I've secured, right? You could sit there, and I'm like, 200 pounds and 195 pound guy. I can sit there and hang off some of the things I do. It's because I just don't want no one to take it. I've got like
it's bolted down.
I've got it crazy glued, industrial glue with these screws going through. Like you would have to tear down the wall to take this, right?
I bet you got a secret room somewhere, just like.
I can't tell you.
I don't want to know. I don't want to know. All right, moving on. Getting into a sticky situation here. Okay. So let's talk about the European Union privacy, right? So the European Unions take a really aggressive pro-privacy stance for their constituents. One of the key things they've done is the EU Data Protection Directive, and this allows for the free flow of information while still maintaining consistent protections for each member nation's citizens' data. Now, the interesting thing is there's a few pieces and principles of this directive, and one is notifying individuals how their personal data is being collected and used, right? So when we're thinking GDPR, these are the things they have to abide by. So they notify the individuals. They allow individuals to opt out of the sharing of their personal info. They require individuals into sharing, requiring individuals to opt into sharing the most sensitive personal data. Now, to Sean's point where he says name, address, and phone, I don't know if those three pieces are the most sensitive pieces. I think they have to opt in, probably health records, things like that. But I think name, address, phone, like those are things that are pretty publicly available at this point. They may not have to opt into that, but we'll have to clarify in a future episode. Mm-hmm. And last but not least, they have to provide reasonable protections for personal data. And if not, they get the pantsuit off them, right?
Oh, for sure. I mean,
fined off them at least.
And this is what we're talking about, like when you're looking at, PIA information being released, right? The fines and everything that these people going. Now, don't get me wrong, when we look at the, European agency versus U.S. versus Canada, we're slowly in Canada, starting to catch up. But when you look at United States to Canada, like, I know what California came out with a lot of different restrictions for when it came to data and data protection. European with GDPR is starting to come up with a lot of better laws and regulations. We have PIPEDA here in Canada, so we're starting to do that. But again, it's
PIPEDA.
PIPEDA.
PIPEDA. Spell that for me. Throw it in the LinkedIn chat. I want to see it.
Okay, I will throw it in there.
And is this just like your GDPR equivalent?
Yeah, that's right. And
do you know what the differences are or no?
I'm starting to learn it. It's kind of the same thing as notifying if there was a breach. Gotcha. It stands for the Personal Information Protection and Electronic Document Act.
Jeez, could they pick a longer name?
No, well, yeah, it's Canada, right? We're just going to make it as long as possible.
What do you expect?
Right, so, but the point of it really is just to understand how to protect the data, right? Any electronic source notification, like you're talking about, if the data has been breached or anything along that line, making sure that you're providing notification to the users of the data and then letting them opt out. It was kind of the same kind of concept.
Very cool. And so I think most people are starting to do that. Now, there's an interesting privacy guideline that you guys need to know that I'd never heard of before. And it's the OECD. And the actual name, once again, the OECD Privacy Guideline is the Organization for Economic Cooperation and Development. So the funny thing is it says economic cooperation and development, but really it's talking about data and data sharing. So though this is often considered exclusively European, there's actually 30 member nations of the OECD. And it includes United States, Mexico, Australia, Japan, and the Czech Republic. Now, this is a forum in which countries can focus on issues that impact the global economy, but it often routinely, it says routinely, but one of the most recent examples was 1980, so I don't know how routinely this is, but it basically sends recommendations for current policy changes and legislation for those member countries. So one of the examples was it was a guideline for the protection of privacy and transborder flows of personal data. So I'm going to guess on the exam somewhere you're going to hear about transborder flows of personal data, and you're going to need to know that's an OECD guideline. And basically what it's saying is it's recommending and pushing a basic framework for the protections that should be afforded citizens' personal data as it goes across different world economies.
Right. So that's important.
Sorry.
It is. It's a lot to. So give us an example. How would that be used? How would that be implemented in what we're doing the day-to-day transfer of data and information?
Yeah. So, I mean, once again, this was 1980. So I'm going to guess it's not going to go into, encryption in transit, encryption at rest. Like, I don't think back in the 1980s they were doing that. So hopefully they have better and more up-to-date recommendations since here. But a few of the driving principles about the privacy of personal data from this are the collection limitation principle. And this is personal data collection should have limits, right? So should it be obtained in a lawful manner? They shouldn't be pulling everything out of your phone without your permission like TikTok is. Did I just throw that out? Anyways. Unless there's a compelling reason on the contrary, right? Without the individual's knowledge or approval. So hit me with the data quality principle.
So you got the data quality principle. Personal data should be complete, accurate, and maintained in a fashion consistent with the purpose for data collection. Does that remind you of anything from the CIA?
What do you have in mind?
Confidentiality, data integrity,
Yep.
availability.
There it is.
Right? So,
But I'm taking this a different direction.
What's that?
I'm taking this a little bit different direction. Like data quality principle, what if I want to manipulate something to make my company look better? But you're right. It's CIA triad, right? Confidentiality, integrity, and
integrity of the systems or integrity of the data, right? And the integrity of the data is make sure it's complete, accurate, and maintain the fashion consistent with the purpose of the data collection.
Yep.
So, and I bring that back full circle because I know we talk about CIA, and it's something that I've been listening to some of the podcasts as well as some of the study. They keep bringing it back to having that concept in your mind. CIA, as you're thinking this, confidentiality, data integrity, and availability. And this comes right. Yeah, the integrity of the data, making sure the personal data should be complete, accurate, and maintained in a fashion consistent with the purpose for the data collection.
Yep, that's it. Now, the next principle is purpose specification principle. The purpose for the data collection should be known, and the subsequent use of the data should be limited to the purposes outlined at the time of collection. That's a pretty good one in my opinion. Like, you can't just take the data and decide you want to use it for something completely different, right?
Right.
At any time you desire. So that's that one.
Facebook,
yeah. Hit me with the use limitation principle, Brandon.
The use limitation principle: personal data should never be disclosed without either the consent of the individual or the result of legal requirements. Right. So a warrant. Right.
Sorry, I'm laughing because how many breaches have leaked all of our data without my consent or without a legal requirement, right?
True.
Like
very true.
Target leaked all my credit card info. Equifax leaked all my identifying personal information. What else?
Oh yeah, there's so
banking
many.
ones. I couldn't list them all if I wanted to, Brandon. So yeah, these are great principles, but
it'd probably be best to list the ones that haven't.
Yeah, Coca-Cola. Okay.
There you go.
The next one is security safeguards principle, and this is personal data should be reasonably protected against unauthorized use, disclosure, or alteration. CIA triad, right? Hold on real quick. Here we go. Sean Delane says, much of this is now spelled out in CCPA. Are you familiar with that?
No, what is that?
Well, Googling it now.
Sean, we are Googling it.
GDPR versus CCPA cheat sheet. Looks like I have some studying to do.
Does.
So, yeah, it looks like it's the California Consumer Privacy Act.
And that's what I was talking about earlier. And I didn't know them. Like, I mean, again, being Canadian, I'm just hearing a lot of them. But that's what I was saying. Like, there's a lot of data protection and a lot of laws coming from California, which are really good, and they're starting to protect data.
Yeah.
So, thanks, Sean.
Yeah, that's great. And I think California does have like in there an openness principle, right? So a policy concerning the collection and use of personal data should be readily available. So if you want to know how it's being used, you can request that. And then, hit me with the individual participation principle.
Individuals should be able to find out if the entity holds on their entity.
I got you.
Yeah, you got me. Thank you. Holds on their personal data, made aware of any personal data being held, given reasons for any denials to account for personal data being held, and a process of challenging any denials, able to challenge the consent of any personal data being held, and have a process for updating their personal data if found to be inaccurate or incomplete.
Yeah, and so Sean once again is hitting us left and right. Yep, California Consumer Privacy Act, and he's saying this could potentially lead to nationwide privacy legislation, which, to be honest, is long overdue, in my opinion. Mm-hmm. I mean, right?
Oh, for sure.
Like, these things are principles from 1980, but how much, like, what, do you remember 1980?
Do I remember it?
Yeah.
Yeah, I remember Boys to Men. Yeah, I remember it.
How much technology and how much of your data was online at the time? None. So these principles were from back when they were collecting stuff probably via mail, like mail in your rebate, right? So yeah, I'm right with Sean. Like, I hope that this leads to nationwide privacy legislation. I think California may take it to another level.
I hope so.
I like seeing that stuff land really in the middle so we can still encourage innovation, But yeah, protect the consumer, right?
For sure.
Good stuff. And last but not least is the accountability principle, and that's the entity using the personal data should be accountable for adhering to the principles above, which they sometimes are, sometimes aren't. They settle with class actions, and we make $10 after all our data has been leaked.
Awesome. We got 2 more sections.
All right, cool. And we got 4 minutes to do it. So EU-US Safe Harbor. This was a European Union Data Protection Directive that was about the European constituents, and they basically said the U.S. doesn't have the same standards we do, so it made the U.S. and the EU come into an agreement so that they could share data consistently, right? And they could be part of this safe harbor together. Did you get anything else out of that I missed?
No, that was it. And then I know it says that this presents a challenge regarding the sharing of data with the United States, which is perceived to have less stringent privacy protections.
Yep.
And
it also relates to U.S. organizations have to voluntarily consent to the data privacy principles that are consistent with this EU data protection directive above. So
exactly.
The organizations themselves have to agree to it.
Right.
And last but not least is the infamous U.S. Privacy Act of 1974. So this is where all governments have a wealth of PII. And this Act of 1974 is created to codify the protections of U.S. citizens' data that's being used by the federal government. So I guarantee you this one's going to be on the quiz for the certification. But the Privacy Act of 1974 provides individuals with access to the data being maintained related to them with some of the national security-oriented exceptions, right? So if it's part of a TSSCI-related program, obviously the government doesn't have to disclose that info about you. But for the most part, do you have any examples of this? Like, what part of the government could you go to and get your data from?
I'm starting to think in Canada.
Oh, yeah, you're in Canada. I can't think of one here in the U.S.
We can go to Service Ontario.
Okay. I mean, we could, right? So we could go and request that from Social Security Administration. We could go to, but once again, like, it's just strange because they don't advertise it, right? Hey, just send it here. We'll send you all the data we have on you. You know, they're not as keen to do that, but the act exists, so technically they should be able to. So, any closing comments for us, Brandon?
No, I think we covered a lot. Now, I'd love to hear from you guys, everyone that's watching this. What did you guys think of this episode? Give us some feedback in the chat. I'd love to kind of hear your feedback. I know for myself, when you look at all the privacy, and you look at all that, really gets me questioning kind of where we're at in society right now with social media and all the data and, you know, Generation Z, Generation Y, and how much information they're giving out there. Like you talked about, you kind of dropped it, was TikTok and, you know, Instagram, all that, and all the information that's being shared. It's interesting to see, you know, where our data is being released, right? Because before, if you talk to my grandparents, and I know probably yours, they wouldn't say anything because the Russians are going to get it, right? Like the Russians are going to get everything. So you just don't say anything. You don't, like, you hide everything, right? But now it's just like you have your whole life online.
Well, and not even your whole life right now. Like, did you upload your photo and do the Age Me Plus 30 Years app that Russia came out with?
Nope.
I didn't either, but millions and millions and tens of millions of U.S. citizens did, right? So now they have facial recognition 30 years from now on you. It's crazy. It's just absolutely bonkers. So once again, Veterans Benefits. Sean, that's a great one. So you could request your info from Veterans Benefits. That's a great add to this. Once again, thank you all who participated. Sean Delane, you've been great. Christine Bacoy for being on. Once again, my boss actually jumped on. Wallace-san. Tim, thank you guys all for joining. Everybody who participated, we appreciate you, each and every one of you. This was show 5 of Cutting into Cybersecurity with Joel and Brandon. And next week, we'll be covering the IC Squared Code of Pro Ethics, along with other topics. Thank you guys so much for joining us, and have a wonderful rest of your night. And that's a wrap. All right.